What do we want to do? On the people, Levon Golo. Let's go with Levon Golo first, please. 24 CR 1314. What are we going to do on her, please?
I'd ask for some more time on Ms. Golo's case. I hadn't had a chance to discuss her case with her.
You got 4 weeks. Okay. Thank you. Please get a resetting, ma'am. Thanks for waiting.
Thank you.
Kay Elaine.
Let's ask you. She's already been reset.
Yes, she's ready.
What, how long were we resetting this fellow?
Covina McClellan. She's been reset too. Arlena Solomon.
I'd ask you if we could have 4 weeks on her too.
We're gonna reset this always. Okay. Please get a reset. Can we get some work on either get a disposition, something within at that next setting?
Yes, sir.
One way or the other, please?
Yes, sir.
Okay.
No.
Go
He said he seen parts of the video.
Man,
He said he seen a little bit of the video, but
he needs to see it all. Okay.
Yes, sir. I need to see it all.
Who's next in the group?
That was Miss McClellan, I think, the last one.
What's your name?
Lavina? Yeah, Marcus. There's Marcus Miles. What are we doing on Mr. Miles?
I hadn't had a chance to talk to Marcus yet.
Stand by. He's going to talk to you next. Okay. Here's Levon Godlow and there's Marcus Miles.
That's yours.
Covina McClellan. Where was Miss McClellan?
I think it was
No.
reset.
What?
That written down.
McClellan? Okay, that's reset. Marcus Miles. That's going to be Marcus. And we're going to,
Probably gonna reset
Who's
it.
Carlina Solomon?
Try to talk to him.
Solomon, we just reset. McClellan.
Romero Williams. What is your name, ma'am? Your name.
it's more.
This is
First
Laura.
Miss
She was the one who
Off the initial. Okay, I need
came off the
files for the
initial.
initial. There's 2 people off the initial. All right. Carson Moore in 25 CR 497, charged with a 2nd-degree felony of assault on peace officer, up to 20 years in prison. You're looking at, but today, what is the announcement? What are we going to do today? It's what are we going to do? Resetting
I think reset it, Judge.
for what?
4 weeks.
For an announcement? Is
Yes,
that what
sir.
we're going to do?
Yes, sir. I'm
Okay,
sorry.
make a decision in 4 weeks. Thank you. Get a resetting, ma'am. Thank you for waiting. Sorry. Marcus Miles. Mr. Miles is up there, 24 CR 1680.
Highlighted that's the one that he hasn't spoken to yet, Judge.
He's the one I need to speak to. I've spoken to, I think, all these ladies, but just like.
Romero Williams is one we haven't called, and I did not get Miss McClellan to sign a resetting. If she's still here, she needs to be
So I come in
August 7th.
Which case is it we're waiting on the probation officer for?
It's here tonight, it's all Jones.
That's with
What's the name? Which case is it?
Syracuse.
Okay. And,
Judge, I'll go speak to Mr. Miles and be right back.
all right, talk to him. And finally, Romeo Williams.
$400.
How much?
$400. The amount includes
$5.
$5. So someone came and made a payment. There was an original amount of $700. They made a payment of $300 in the last few days. Maybe on the 12th, I believe. And then, so that leaves a balance of $400. But technically, right now, what is due is $5.
It's
$5 on the restitution.
because he's paying in installments.
Correct.
Okay. There is in 23 CR 1012 Harold Randall Hughes. That's you, sir?
Yes, sir.
You were here with Mr. West, your attorney and the state's attorney. Hey, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. There is a motion to revoke probation that was filed on August 1st of last year, and we need to move forward on that. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes,
Mr.
sir.
West.
Yes.
In summary, sir, this motion to revoke probation states that on November 13th, 2023, in this court, you were sentenced to 2 years in the state jail. That was probated for 5 years for forgery, for the forgery of a financial instrument, a state jail felony. Is all of that true?
Yes, sir.
Allegation 1 states you failed to report to the Jefferson County Probation Office for the dates of May 9th and May 30th of 2024. Is that true or untrue?
Yes, sir.
You can explain a little bit. Is this true or not true? Now the most I make explain.
Yes, sir. It is true.
Number 2 states you failed to provide verification of performing community service hours as required. Is that true or untrue?
Yes, sir.
And then finally, the states you have failed to pay court assessed fees as directed as of July 17th last year. The states you were $960 in arrears. Right now, what is the arrearage?
$1,980.
Yeah, those things never end. But the important thing is restitution is still owed in the approximate amount of $400. And that's what's important to this court. When can that be paid, do you think?
As soon as I get out, Your Honor.
Like
2
the
weeks.
day you get out?
Yes, sir. 2 weeks.
Well, I don't want to say the day he gets out. I'll give him a little time, but
Okay. So you understand what you're charged with in each of these, and you're pleading true or stating it is true on allegations 2, failing to provide verification of performing community service, and then the arrearage. Were you able to pay? Are you paying as much as you can?
Your Honor, he has been in custody at the GIST.
I know, but there's still people in custody and then people on their behalf. Or are you paying as much as you can?
Yes, sir.
Okay, that's all that's
Yeah,
important.
his
Yes,
mother's
Your
been
Honor.
paying.
Right. Failing to report here on May 9th and May 30th of 2024. What's that all about?
Your Honor, he was after he got placed on probation here. He was out on probation. Had checked in a few times with the probation department. Was getting going on probation, and then his bond out of Orange got revoked. He had a case over in Orange. He went over to Orange, and then they eventually sentenced him 1 year state jail. That's why he went to GIST, and then they were brought after he got
When
to
did,
GIST.
I mean, was that during May 9th and May 30th when he should have been reporting?
Yes,
Yeah.
Your Honor.
And then
Do we know that for sure?
No,
Okay.
we
well,
were relying
you can't-
upon defense counsel to
and
Well,
we-
I mean, he can't be in jail and also out reporting at the same time. That's impossible. And that's a defense if he is in jail.
I want to repeat, Judge, whenever we were here earlier this week, counsel made this claim. It was reset for him to bring proof about
What
the
do we
time
have
that
on
he
that?
was in custody. If that has not been done, I'm not prepared to move forward. I don't want to go forward on mere accusations that this
Oh.
man makes. I was told that there would be proof about at the time he was in custody.
Yeah.
Your Honor, we
I mean, he's on probation for forgery. We're going to make sure to verify
Yeah.
everything.
Your Honor, I should be able to get that document today. We've been working on with the GIST unit to get some kind of proof. Apparently, that supposedly, whenever he was sent to the jail, they should have released that to the jail, but I have not been able to get a copy of that.
What are we going to do today?
Today, I would request if we get this document and by the end of the day, and I'm working, like I said, I've been working on trying to get them to give me something, email me something. My request is to continue on probation because if he was in GIST jail, which I have no reason to doubt that he was in jail, because that's where they went and got him from our jail, got him from there. Then let him on probation and come back in 3 months to see if he's made progress on making payments now that he's out and he can do that, and see if he's done his community service. Because right now the allegations are issues where if he was in jail, he couldn't do this stuff.
Okay.
So
I'm gonna have to
There's a
make
way to
some
avoid
comment,
all of that.
Judge, because when we were here, initially I was told earlier this week that he never was released, that he never had an opportunity to report. I got with the probation officer, and the facts is that he did report on 2 different occasions. I advised defense counsel about that. The burden then shifted to counsel to provide proof about the accusations they were making. Again, we're standing here, the probation officer and I, because it was set this morning. So I was under the impression that we would have that information. Now we're being told we don't have it. We'll get it later. I've not made any attempts to do my own independent research because I wasn't even aware that it was on the docket today.
Don't mean to keep him in jail, but I'm gonna do that until you do
Let's
it. Fine.
get us, if we can go to the jury room and make some phone calls with him, he has to verify.
Look,
I can't
I'm
get-
not doing it. Y'all have to.
But I think if you give me I know there's
Please.
issues about going to the jury room. If I can have some time in the jury room with him, I know there's stuff happened earlier this week. Give me about 10 minutes. I should be able to make some phone calls and get some email to the court.
Okay,
But I don't want to walk away from the court. If the court says we can excuse, we're going to do that right now.
yeah,
Okay, let's go.
okay. Stand by. David, do you have something?
No, sir, just one more to reset.
What is it? Which one?
He just waited around longer than
Yeah.
everybody else.
24 CR 1681. What are we gonna do then today?
Judge, we would like for just a little bit more time. He is going to be pleading guilty for some incarceration time. He would like a short time to go and place some of his children because they are all out.
Today is my son's ceremony. Today is his ceremony. And,
How much time are you asking for?
I'm about to see.
I'd ask for 4 weeks, but 2 weeks at least, Judge. He will come back here and he will plead guilty and he will be in incarceration.
Is that the plan?
Yes, sir.
3 weeks, you got 3
You can do both.
3 weeks?
3 weeks.
Yes,
All
sir.
right, then, that way.
And Judge,
Get it resetting.
Mr. Gross still has 2 clients that did not come sign a resetting. I'd like for them to come in if possible, so we can get their signatures. Ms. McClellan and Mr. Williams, if they're still here.
Here, just get a resetting.
Mr. Miles.
This is Mr. Miles.
Yeah, I understand.
Well, he can go. He can sign and go.
All right. I thank you too.
Yes, sir. Yes, sir.
All I need is McClellan and Williams to come in and sign a resetting, if someone could.
Where's
Call her
McClellan
out.
Williams?
And if y'all can look a little more deep into that, cause there's some stuff missing. They didn't put some stuff in it.
Yes, sir.
Mr. Miles, here's the resetting.
Okay, can you call into the hall for, what's her name?
McClellan and Mr. Williams.
Stand by.
Romero Williams.
Bovina McClellan and
Romero Williams.
Romero Williams. Bovina McClellan and what's going on over there? Come on, Mr. Book. Trying to get, Mr. Wilkerson is on the screen. We just don't have him on the big screen. Can you hear us, Marcus?
I can, yes, sir.
Okay, so there we go.
For the record, I assisted in that.
Okay.
There it goes.
All right. There he is in the. Okay, all parties are present here in cause number 23 CR 1490, the state of Texas versus Joshua Booker, state of Texas. The defense attorney is in this hearing via Zoom. All right, what is it that the defense is asking for here at this late date?
Yes, Your Honor. So we're asking for an independent DNA test, and we didn't request it before because we were under the impression that the state was going to conduct a second one. And I'm not, and I have a duty of candor with the court. I'm cognizant of the fact that typically when there's second or independent DNA tests, you've got a situation where there are potential multiple contributors to a surface or something of that nature, and we're not dealing with the paternity test. Mr. Booker has maintained throughout the pendency of this matter that the DNA test, that there had to be some problem with it, that he is not the father of the child born to Malaja Davis, daughter of Danielle Davis. This case is set for trial on Monday to begin. And Judge, just a little bit of history. So the originally, the person who did the initial analysis didn't work for the same lab anymore. So back in January, this case was reset with the understanding that there was going to be some additional DNA testing conducted. However, the state has since been able not only to have a second expert analyze the raw data and be prepared to testify, but I was informed yesterday, shortly after filing this, that indeed the original analyst will be present to testify about the comparison and extraction that was conducted in this matter, Judge. And I have to tell you as well that I'm not aware of any quality of service matters arising at the lab during the period of time where this sample was tested. Nonetheless, it is my client's assertion that the DNA test that was originally done is somehow not reliable. He asserts that there had to be some sort of cross-contamination of some sort, and therefore is requesting a second independent test, Judge.
Your Honor, I would argue that number one, it's untimely. They've had plenty of time to test this on their own if they would like to have done that. Also, the lab that tested this is Endeavor Laboratories in El Paso, Texas. Beaumont Occupational Services is the only person I know around here that does the paternity testing, and they send all of their testing out to Endeavor Labs to perform the actual analysis and the testing on the DNA material. They would still send, and it's my understanding that if Mr. Wilkerson were to use somebody, it would be that same Beaumont Occupational Services. So it would be tested by the same lab, by 3 of the same analysts who tested this stuff initially. And there's also a paternity order where he has been ordered and deemed the father of the victim's child in this case, that the 12-year-old victim that was impregnated. There's again nothing to suggest. Also spoke with Mr. Daniel Slawinski at the lab. There's been no testing analysis. It hasn't been updated anyway. It's not any more accurate than it was in 2023 when this testing was performed. He advised me that it would be the same exact testing that would be performed that they performed for this test. There's no, updates in science or that's going to make it any more accurate or any better than what it was back in 2023 when it was tested. There aren't unknown individuals. The defendant was swabbed by Detective Frank Coffin here at the Beaumont PD, and the victim, as well as her child that she had as a result of the defendant. Swabs were taken of those as well, all sent to Beaumont Occupational Services, which were then sent to Endeavor Laboratories, where they were tested against each other, and it found that he was the father to the exclusion of 99.9% of everyone else. So this is, I don't see how in any way the analysis here is going to be tested any better. It's going to be tested by the same exact lab, the same exact analyst, barring one. And we have all those individuals ready to testify in this trial. We've already prepared. We've got flights scheduled for all these individuals, as well as hotels. And this individual's had the entire time that the defense attorney's been on this, that he really wanted this tested, he could have had it independently tested up to this point. I would argue that it's, again, that it's untimely, and kind of looking at Anderson v. State, that's 301 Southwest 3D 276, Texas Criminal Appeals, a 2009 case. And that's where essentially suggested that the court did not
Here.
yes, Your Honor. And he said essentially, though the motion itself was not filed in compliance with the rules, they said even if that were not so, the fact that it was so untimely, being filed at the last minute, that they would not it would not change things as far as that. So they again upheld where a chemist did not test, I believe it was the drugs in that case.
Judge, the only response I have to the timeliness factor, and this is all on the record from the January appearance, that is the appearance where the state indeed represented to the court, and so the defendant was under the impression that a second DNA test was going to be conducted. And so, that in terms of deciding this on the grounds of timeliness, it's not that the defendant didn't assert this claim. It's that we were under the impression, of course, that secondary testing would be done. And so as preparations for the trial had begun is when, the additional circumstance, indeed, the now,
What about
like I
that?
said, I was just told yesterday that the original analyst will be able to testify in the case. So, and that was new information to me, Judge. And so, I've been candid with the court regarding the issues or perspective lack thereof. I would just ask your honor for an opportunity for before the court makes a ruling for my client to make any request or statement on the record as to why he believes or why he feels this testing should be conducted before the court issues a ruling on the matter.
You can't speak for him? Well, you've talked to him. What his story is going to be. What's his contention?
As I've already represented to the court, Judge, it's that the DNA test, that there has to be some sort of error, cross-contamination, because he asserts again that he is not the father of the child.
And Judge, we did not perform the only reason for the testing was not any kind of, there's no question as to the validity of the testing and the results. It was simply because we didn't think we'd have the analyst here. We also found case law, which Mr. Wilkerson is aware of well before this, that allows an independent analyst to review the raw data there and come to their own conclusions on that and to allow them to testify to that. And Mr. Wilkerson was aware that we were going to use the quality control manager there, who's also an analyst, to review the raw data and come to his own conclusion, as well as having one of those original analysts. We were able to locate the other two as well and to get those. And so we weren't going to perform the testing from the time we know that we have the other analyst, that he's allowed to review the raw data and testify to that. It just so happens we happen to get the other analyst as well. And Mr. Wilkerson had a trial well before this that he knew that we could essentially do that, and it was held next door as well, that that was allowed for the other analyst to review the raw data.
What about that?
It is true that there was a trial next door, and there was an objection that was lodged by the defense to an analyst testifying regarding the DNA comparison, and case law was located and presented that indeed that analyst could give that testimony so long as the raw data was analyzed and not just a report from a different expert. And so, yes, at that time, the defense became aware that they would not have to use the original analyst.
Okay. So what are you asking for?
Your Honor, we're asking that the court allow the Beaumont Occupational to come out to swab the defendant and run send to Endeavor or the provider that they utilize, since Beaumont Occupational to my knowledge, is the only one in the area performing the analysis. I did not contact LabCorp. Beaumont Occupational is who I have listed in the pleadings. And so in terms of a secondary independent analysis, that's the relief we're requesting, Your Honor.
Okay, what's your contention about that? What is your contention? Why is that relevant in this case? Why would that be relevant?
Your Honor, again, the allegation or assertion is just that there had to be some sort of cross contamination when the trays were either amplified or tested directly.
No, who says that? What expert?
No, Judge, there's not an independent expert here. Again, the issue is that the defendant alleges that the test is inaccurate and wanted secondary testing. So,
All right, I understand. I think but look, that's when they put the people on the stand to testify, that's what cross-examination is all about. Right? It's to
yes,
question the veracity and the strength of the testimony. That's what's done. That's why cross-examination was invented thousands of years ago, to test the credibility of witnesses. It's the greatest test, that's said. Here, what you're saying is that with this same argument, anybody on the planet can at the last minute come forward and say, I just want another test. And it's not for anything other than, I believe there might be some cross contamination, which is tested. Every case is tested in DNA like this in the same way. Is that somebody makes the test, then the defense has an opportunity in preparation to review those matters, and then at trial, cross-examination is made. But here, saying they didn't do the test right, that is not satisfied. That another test doesn't satisfy that answer. That doesn't change the equation. That doesn't mean anything. That doesn't contest that procedural issue that you're asking for. That's why they put on the experts who did the analysis testify, then the defense cross-examines. That's what's done in every trial like this in experts. It's not something, well, we're at the eve of trial and we don't believe the analysis was done properly. Really? Where does that guarantee you an independent test on that, just because you state on the defendant's behalf he doesn't believe it was done right?
and Your Honor, again, if there were any quality of service issues that I could present to the court, I happily would. I'm not aware of any.
Okay, well, that's why this is done at cross-examination. That's the proper place for it. And just saying by whim, I just don't think it was done right, is not going to open the door to independent testing. Not on this court's watch. And unless you can get me a case that says that's all it takes, it's not without defense. The defense is in the scrutiny of the defense during the testimony at the trial of how it was done. Did it follow procedures? Then the jury makes the call whether they believe there's evidence to show that the test was not reliable. That's the reliability. It's the reliability issue. But by whim, just say, I want another test because I don't believe it was done right, doesn't get across the finish line. It's not, you're not without a defense. You're not without the ability to question things and scrutinize it. You're going to be given ample opportunity to do that. And the jury makes the decision of how much weight and credibility to give to all evidence and testimony at a trial. We're not going to change they're the fact finders. They're the ones that make the call. But at the last minute after this case has been languishing here for a while, what is it?
It's about a year, little over a year old, Judge, or a little over a year old on my watch anyway, I should say.
It was indicted September of 23, sir.
Okay. And yeah, I believe I was appointed in May of 24, I believe.
Over 20 months. And then on the last workday before the Monday trial specially set on this, by just the reason I don't believe the test was done right. I want to redo everything and have independent DNA testing. The court doesn't have anything before it that shows that is an automatic right. And without better cause than what you have suggested, the court does not see that it's necessary, and it is going to be taken care of by thorough cross-examination and arguments of the defense and the scrutiny at trial of the methodology used in the testing.
I understand, Your Honor. As the court's aware, I have a responsibility to my client, and he advised he wanted to pursue a second test, and so
I meant it. You raise things. You have to vigorously represent your client. And that's important. You're entitled to do it, but the court is going to does not grant all decisions, and doesn't grant all requests. And in these circumstances, the court finds that it is not. It is unnecessary for a proper defense. We open the door. We would be retesting every scientific methodology used along the way, and that is not what the law says is required. Is all tests must have an independent testing done for questioning. That's why the people are under oath presenting the evidence. They are cross-examined, and the jury makes the call on how much weight and credibility to give. That's where that is the proper place. This court finds is the test, and where the defense efforts are to be in this particular set of circumstances, not independent testing under these circumstances. I don't find that that's not the answer to this, that they didn't handle something correctly, or that the steps along the way were not performed correctly. That doesn't open the door for an independent evaluation of the evidentiary item at issue. And the state has the burden of proof to convince the jury that it was done right anyway. So they're the ones with having to climb the mountain.
Excuse me.
If they can. Anything else? That is all.
Your Honor, I would just note that the Attorney General's office relied on the same test. They didn't test it. Again, they relied on this to determine the paternity and the CPS case as well.
Did you understand that to be a fact?
Yes, sir. Yes, sir. I obviously I don't represent Mr. Booker in those matters, but it is my understanding that there was an adjudication of parentage based on the testing that was conducted in conjunction with this case.
Okay. Was there anything that independent evaluation saw, or anything suggesting that this testing that you're at issue over was not valid in any way?
There were no issues of any nature of that nature raised in conjunction with the paternity determination, Your Honor, in the family court in the CPS case.
And who did the evaluations on those? Or the determinant? Did you say that's general?
Well, there was not other testing. They've just reviewed this report. They based it off of this, so they didn't do duplicate testing, having to waste state resources on that. But I'll have to see.
Wait a minute, but okay.
Yes.
But there was no indication that there was anything inappropriate or questioning the validity of the results.
That's correct, Your Honor. That's what my understanding, speaking with CPS on this. Yes.
Okay. It's there again, is if this were the way it should be, then their analysis needs to be independently attested. And that's not independently examined. And that's not the way it works. It's the fact finder will make the decision on accepted, valid testing. And the issue that you're suggesting is the manner and means in which it was evaluated by the testing authority. And that's what for a jury to decide after they hear all the evidence, including cross-examination by the witness. All right, your request is denied for those reasons. Thank you. All right, what do we have next, John?
Yes.
Harold Fuse?
Yes, sir. Yes,
Hey,
Your Honor.
welcome. All right, let's get to this. Since we're about to go into our afternoon
Yeah,
docket, this is so, this really took way too long, folks. All right, what are we gonna do? There's a motion to revoke probation here,
I'm going to dismiss the motion. He just handed me that he was in jail for a year.
sir.
Yeah, I just gave him the document that he was in jail for a year and actually 3 months.
Oh, okay. So,
So it's 15 months actually. He was in jail.
all right, send me a dismissal and we'll sign it.
Yes, ma'am. Thank you. God bless you. Thank you.
You want to say anything?
Thank you, Your Honor.
Oh,
Thank
no,
you.
I mean,
Oh,
you didn't, you know, you got the good, you're in the, rolling in the right track. So what are you gonna do next?
I'm gonna get a good job and raise myself.
How old is he?
He's now.
Good. Well,
Good to.
what's the best gift you can give to your child?
Being his life.
Well, how about living a good example?
So.
Your child is going to do what you are. They have a natural tendency to emulate their parents. So live a good example so that your child will have a good life. Okay. Thank you.
Your
for
Honor,
that.
can I get you paperwork?
Oh, yeah, you got all the paperwork you want, but get your lawyer to, hey, John, he's talking about, he needs some copies of paperwork. Have you talked to him about whatever he needs?
It's out and we can, well,
Okay,
yeah.
thank you. We're in recess.